Now, in barely 24 hours, a 7-member Supreme Court panel is to deliver its ruling in a review application filed by the Attorney General, Godfrey Dame. Mr. Dame is asking the Apex Court to set aside its July 2021 close call, that's 3-2 decision that barred Justice Clemens Onyenuga from continuing as judge in the trial of former COCOBOD CEO Dr. Stephen Opuni. One of the 2 judges who agreed with the AG's position in July is being asked to recuse himself from the case. Lawyers for Dr. Opuni have filed documents at the highest court alleging that Justice Dotse is said to have held meetings with the Attorney General days after the Supreme Court had heard the oral argument and adjourned to deliver its ruling Tuesday. But Justice Dotse has been fighting back. He admits he did meet the AG, but it was on law school matters. MFA Paul joins me with details on this matter. MFA, first of all, Justice Dotse has been fighting back, but before we go into that, tell us about the claims that Dr. Stephen Opuni has been making.
Right, Ernest. So amongst others, he has up toward a 19-point argument that he makes and gives a background as to how Clemens Onyenuga, as you recall, was asked to recuse himself. Then he goes on to say that his attention has since been drawn to a widely circulated internet publication by one Kelvin Taylor, a Ghanaian broadcaster in the United States of America, who states unambiguously that the Attorney General, the applicant hearing on Friday, 15th of October, went to the office of Justice Dotse, the presiding judge, and had an extensive meeting with him. According to the said broadcast, the meeting lasted for over 2 hours, he says, and also goes on to cite concerns about this case taking a political turn. And he says that as a result of this unfortunate political coloration of his case by the Attorney General, who by virtue of Article 88 of the 1992 Constitution is the prosecutor, other bigwigs of the ruling NPP party and its political appointees, newspapers and commentators sympathetic to the ruling party have published untruths about the case. He is therefore not in any doubt that his case has been unnecessarily elevated to an instance of corruption of the NDC, the success of which would have a bearing on the political fortunes of the present ruling party, of which the Attorney General is an appointee. So this is the case that was made by Dr. Stephen Opuni.
So that is the grounds he is seeking the Supreme Court to act on to remove Justice Dotse from that panel. But in Justice Dotse's response, he flatly denies some of the depositions, and there are some he gives explanation for. Run us through the various areas.
Okay, so he says that his attention has been drawn to this application, rightly so, and says that, save that in my capacity as acting Chief Justice during the absence of his lordship. This is the point where he responds directly to the claims that he had a meeting with the Attorney General. So he says that as acting Chief Justice during the absence of his lordship, the Chief Justice in Inyabwa, from the country from Monday, 11th October 2021 to Monday, 18th October 2021, the Attorney General paid a visit to me in my office. I deny the remaining advertisements contained in paragraph 6 of the affidavit in support. In further denial, I state that the visit of the Attorney General was in relation to matters concerning the Ghana School of Law, because I had also assumed the position of acting chairman of the General Legal Council. Okay. He goes on to say that indeed, anybody with sound legal knowledge and training will understand that in the course of our work as judges, it is normal for judges of my stature and the Attorney General and the senior staff of the Office of Attorney General, the Ministry of Justice, to come into contact on regular basis. So point 7, for instance, says that apart from issues touching the Ghana School of Law, which I discussed with the Attorney General on the 15th of October, and which did not last more than 20 minutes, I believe that the instant application has been actuated by malice and poor judgment, responding directly to the talk that he had with the Attorney General and the claims that was made by Kelvin Taylor. So he goes on to also state in point 10, where claims were made that Justice Clemens Onyenuga was his close friend. He says, Justice Clemens Onyenuga and I were colleagues at the bar in Ho, and indeed, are close friends. The impression created in paragraphs 14, 15, and 16 of the affidavit in support are illogical and are not sufficient to require that I recuse myself Otherwise, any other judge with sufficient knowledge of the presiding judge must equally recuse himself or herself. So these are the points that Justice Dotse makes to refute the argument that was put out by Stephen Opuni and his lawyers for him to recuse himself barely 24 hours for the Supreme Court to make a verdict on that particular case.
MFR, thank you very much for bringing us those details. And of course, we'll be in court for you. We'll tell you what happens on the substantive case.